Yes, Judge, I'd like to call Ms. Lewis, please.
All right. She's been sworn.
Ms. Lewis, can you state how you are related to this case?
I am the permanency specialist caseworker.
Okay, and how long have you been the worker in this case?
Since about mid-October, beginning of November.
Okay, and how long has Serenity lived in Miss Haley Wells's home?
To my knowledge, about 1.5 years.
Okay, would you say that that is the child's entire life that she's lived with Miss Haley Wells?
Yes, she was. She came home from the hospital and went to Miss Wells' home, to my knowledge.
And to your knowledge, can you briefly tell the court how this case came about?
To my knowledge, Ms. Showers tested positive at birth.
Objection, Your Honor, no personal knowledge and hearsay.
Judge, she's the custodian of record. I could put that on if that's needed.
She wasn't.
Why don't you go ahead and prove her up as a custodian?
Okay, Ms. Lewis, as part of your job, what do you have to do to get prepared for these cases?
We have to review the history of the case, start a service plan for the parents to begin services, understand the reasons for removal.
And the record, why is it important that you pull the record and review it?
So we understand the reason for removal.
And do you pull the record during the normal course of business in these types of cases?
Yes.
And any documentation regarding this case, is it filed in the case that you are in charge of?
It should be, yes.
And do you have to familiarize yourself with the history in order to provide the parents with a service plan to address the concerns the department has?
Yes.
Judge, I'd like to offer her up as the custodian of records for this case.
All right. Court will designate Ms. Lewis as a custodian of records in this particular case. And the objection is overruled. You may proceed.
Can you briefly tell this court what brought this case before this court?
Substance abuse concerns?
Your Honor, I'm going to still object if hearsay. As a custodian of records, she doesn't get to get anything but records in. It's still hearsay. Anything she knows, she has no personal knowledge to.
Overruled.
Substance abuse. Ms. Showers tested positive at birth with Serenity.
Okay, and to your knowledge, were there any issues that the child had due to that substance abuse?
Yes, there were withdrawal symptoms. Yes.
Okay, and do you know how long that lasted?
I cannot remember off the top of my head, but I believe for a few days.
Okay, and in this case, once the child was released from the hospital, where did she go?
To Miss Wells' home.
Okay, and have you witnessed the bond between the child and Miss Wells in this case?
I have been able to go to the home, and yes, I've witnessed a bond.
Okay, and can you describe that bond to the court here today?
Serenity is bonded to Haley. She is able, she goes to her when we're sitting talking, and she, reaches for her. So I know she's comfortable in her arms, things like that.
Okay, and has Serenity ever addressed, how does Serenity address Miss Wells in front of you?
She's
still kind of babbling, but she, like I said, she'll kind of reach for it.
Yeah. It's an out-of-court statement by a child.
Judge, she's the subject of the suit, and she has personal knowledge of that, Judge.
Overruled. Well, she's talking about how the child's babbling, so I'm not sure what I'm going to get out of that other than the fact that the child's making noise, so I'm going to overrule it.
But yeah, she reaches for her, and yes, we'll kind of mumble, babble, Mama, Haley.
Okay. And during this case, how often would Ms. Showers visit with this child?
To my knowledge, she had weekly visits up until she moved to San Angelo. And then after that, she had 4 hours monthly, just due to the travel on Ms. Showers.
Okay. And going back a bit, in reviewing the file and getting ready for this case, in the past, did Ms. Showers have any issues with domestic violence?
In past cases, I have read that, yes.
Okay, and was that a concern for the department that required a service, be a part of the service plan?
It was a concern in her family plan of service, yes.
And to your knowledge, was she the victim or did she also engage in the domestic violence?
To my knowledge, she was a victim.
Okay. Now, originally, what were the services that you were asking Ms. Shower to complete?
Her inpatient, along with an outpatient program after. We also asked her to do individual counseling, a psychological parenting class, and addressing that past history of domestic violence. I don't believe she took a full-on BIP class. However, I know she did complete South Texas Life Skills had a domestic violence intervention program that she did complete, and she addressed it in San Angelo with her victims advocate.
Okay. I didn't hear you mention anything about couples counseling or couples therapy.
Couples counseling, yes, we would like them to engage in that. I did get a couples counselor to start with them. However, we're having a little scheduling issue between 3 people's schedules.
Okay, and a part of the original service plan, there was no couples counseling or couples therapy. Is that correct?
Not at that time.
And can you please explain why there was not those services included in the original plan?
To my knowledge, it was because they were not together at that time.
Okay. Would you say that there was a concern as to whether Ms. Shower, Mr. Del Toro were being upfront and honest about their romantic relationship?
There was a concern, yes.
And what was that concern?
The department thought that they were separated and doing their own services. However, it came to our knowledge about November that they have decided to be together as a couple.
Okay, when you say November, that was of 2022, correct?
Correct.
And was that shortly after the father was released?
Yes.
And how did the department find out about their relationship?
Jessica was honest with me when I asked her. She did say that they were together.
Okay. Now, do the department have concerns of Ms. Shower entering into a relationship with Mr. Del Toro in November of 2022 when the case was almost near trial?
Yes, we do.
And what was that concern?
We're just concerned that we have not been able to see them as a. Oh, okay. 1 second. The concern for Jessica or them as a couple together?
Both. That's fine.
Okay. Well, we have concerns that Mr. Del Toro was just released and has not been able to kind of focus on his release out of incarceration, and that Jessica did move right back down here when he was released. And we would like for them to be able to show that they can either co-parent or be in a relationship together in front, so we can see with serenity.
And when parents decide to engage in a relationship, does that in any way affect or change the plan of service?
Yes, if parents are in a relationship, we like their service plan to be together.
Okay, and so in November of 2022, did the department have to make adjustments to the plans of service of the parents because they disclosed their romantic relationship?
Yes.
And what changes did the department make to the service plan?
Adding the couples counseling onto that.
Okay, and you testified earlier that you're having issues getting that started. Is that correct?
Yes.
Now, what issues does this create when we're so close to the trial date, when the plans of service are changed so close to the trial?
It doesn't give the department enough time to be able to watch the two parents, a co-parent, and be in a relationship, a healthy relationship for serenity.
Okay, does that also cause issues on determining whether the parents can provide a safe and stable home while engaging in a romantic relationship?
It does.
Okay. Now, Ms. Showers just moved down to Dilley, is that correct?
Yes.
And to your knowledge, prior to that, what was her housing situation?
She was in a sober living home in San Angelo.
And was it just one, or had she moved throughout this case?
To my knowledge, she had just been in one.
In one, okay.
Oh.
And she just recently moved in Dilley. What are the concerns about her new residence? Are there any concerns?
I don't have concerns about her new residence.
You do not, is that correct?
No.
Okay, are there any concerns of her financially being stable enough to maintain that housing in Dilley?
When she didn't have a job, yes, there were concerns. However, she did provide a pay stub to me that she has a job now, so I don't have concerns of that. She also says she can access government assistance and has told me that as well.
Okay, has she accessed government assistance?
Not to my knowledge since she's returned back.
Has she provided you with at least 3 months paychecks to show that she can financially support herself in this new trailer?
Not with her new job, no, she has not.
Okay. Do you have any concerns of Ms. Shower's visits with the child in this case?
I do not. I have they have been unsupervised, and I have not been reported back of anything negative.
Okay. And to this point, we're almost hitting the 1.5-year mark with an extension. Why is the department not allowed an overnight with Ms. Shower at this point?
I have not staffed for that. No.
Is the department in agreement with the return and monitor in this case?
I believe that the department would like to see the parents engage in their couples counseling and see that they can be in a healthy relationship together. And then I would be staffing for that if that continues.
But at this time today, do you have that information you need to be in agreement with the return and monitor?
I do not, because I have to stop that with my supervisor. I'm not able to make that decision on my own.
Okay, but you don't have any therapy notes or recommendations that would allow the department to agree to the return and monitor, is that correct?
Not by a licensed professional therapist, no.
Okay, and as far as the therapy with Mr. Del Toro, when did he start that?
Oh, he started that right after Christmas with Lucia Cobbs.
And has Ms. Cobbs made any recommendations on reunification with Mr. Del Toro?
Not yet, no.
Do you think that there's been enough time in this case that she can make that recommendation at this point?
I don't think there is. She hasn't seen him as that long to make that recommendation.
Now, Ms. Showers testified that she's taking care of her 2 other children in the home. Does that cause any concern about placing Serenity with 2 other children in the home?
No, as long as they're all being taken care of.
Well, okay, so as you said, as long as they're all being taken care of, what concerns do you have? Could she financially support them?
I believe she can financially support them. Last time I spoke to Jessica, they were just coming over on weekends and spending the night, but she wasn't fully taking custody of them.
Okay. And to your knowledge, does she have any legal custody of any of her other children?
I don't know about her oldest one, but not the 2 youngest, no.
Okay, pass the witness, Judge. Thank you.
Ms. Carla Green.
Yes, Your Honor, thank you. Ms. Lewis, would you describe this case as easy or hard from the department's perspective?
Hard.
Okay, can you just tell the court why?
Because there's parents that love their kid, and there's also an aunt that loves her niece, and there's people that really love Serenity, and they want what's in the best interest for Serenity.
Do you feel like the Department of Belong has, how do you feel the target for this, sorry, let me get a question out. How has the goal in this case changed?
The goal's kind of gone back and forth between relative adoption and family reunification.
And why is that?
To my knowledge, it was due to, I believe the relapse in August had something to do with that on the last family plan of service that I read, and along with the relationship of Emilio and Jessica.
And what do you think that you have done to help facilitate both of these goals and to get this case to an endpoint?
I have worked on getting them in the services that everybody has requested of them. They have had visitation. I believe that we have done everything we can to this point.
At this point in time, it was mentioned in previous testimony about the negative drug test for Ms. Shower. Based on the most recent drug test that came back, do you have any concerns?
I don't, because sometimes people drink a lot of water before they go into drug tests. I've had diluted drug tests come back, and when asked, usually the drug testing facility will say it's just a little too much water, but we were able to still test it for a negative or positive.
And what about concerns about the relationship between the two that you haven't been able to testify to?
I just believe that there's concerns that, to my knowledge, that they were both using prior to Serenity being born and during Serenity's, when Jessica was pregnant with Serenity. So we would just want to ensure that they as a couple can continue their sobriety together in the best interest of Serenity and have that healthy relationship.
So you'd like the opportunity to see them as a couple and how they live as a couple together before putting Serenity back into that mix.
Yes.
Okay. Thank you. Nothing further, sir.
Ms. Savage.
Yes. Ms. Lewis, as the custodian of record, you testified you had to review this case?
Yes.
Let me just screen share. Have you reviewed the mother's psychological?
Yes.
Will you read the highlighted portion for me?
The client then entered into a relationship with Emilio Del Toro. She indicated that he is a wonderful partner who was very supportive. However, she noted that he was incarcerated for drug possession and probation violation in August 3rd of 2021. She currently lives with Emilio's mother. She and Emilio share custody of Serenity.
Okay, and let's just scroll down to when this was done. This was done November 23rd of 21, correct?
Yes.
So the department did in fact have knowledge that the mother was in a relationship with Mr. Del Toro. She was residing with his mother, and she stated she was sharing custody with him. Is that correct?
Yes.
She stated he was a supportive partner.
Yes.
And the department's had that knowledge for over a year and 2 months?
Yes.
And the service plan for either parent wasn't amended to include couples counseling back in November 21. Is that correct?
Correct.
Okay, so the parents were actually honest with the department about their relationship way back at the beginning of this case.
Yes.
Okay. And mother has been honest about her drug use and her relapse throughout this case?
Yes.
Mother has been very cooperative and communicative with the department throughout this case?
Yes.
She has expressed an interest in wanting to see her daughter and wanting increased time with Serenity?
Yes.
Do you have any immediate concerns with Ms. Shower's home at this time?
No.
Okay. And you've been able to go look at that home, and the home is appropriate for the child, correct?
Yes.
Okay. And typically in these cases, the department does favor reunification of a child with the parent.
Correct.
I'll pass the witness.
Ms. Pearsall.
Visits has Mr. Del Toro had with Serenity?
He has had 4, or he will have 4. So 3 at this time.
Okay. And how often are his court-ordered visits?
Twice a month for 1 hour, twice a month.
And he's been out since on or about October 7th?
Yes.
Okay. So he should have had about 8 visits up to this point?
Yes. But I know he had to start services, which he did.
Immediately, correct?
Yes.
Okay, so can you explain why the department violated the order and didn't give him the other 5 visits?
I do know that my case aide, the lady who schedules the visits for me reached out to him in November. However, I think it was a scheduling conflict. But other than that, no.
So is the department planning to make up the 5 missed visits that you owe to Mr. Del Toro per the court order?
I can staff that, and if that's approved, then yes.
And if the court orders you to do the makeup visits that you violated the order, not you personally, but the department violated by non-complying with, you'll make sure that gets done?
Yes.
Objection, relevance, Judge. We're not here for visits for Mr. Del Toro or to make those up. There's no motions on that.
Actually, Judge, there is no motion for Mr. Saldivar to address all visits.
Response.
Judge, I'm just asking the visits be supervised, Judge. I'm not asking to redo visits or cut down visits. And mainly they were for Jessica Shower's visits, Judge.
And Judge, I would argue that this isn't a motion to enforce.
I'll sustain the objection.
I wasn't asking that you go to jail. I was just trying to prevent filing a motion.
Let's move on.
Yeah. Mr. Del Toro was a non-offending parent in this removal, correct?
I believe so.
And generally, the department gives a minimum of 12 months and sometimes 18 for parents to finish their service plan, correct?
Yes.
And in this case, Mr. Del Toro has amazingly finished his service plan outside of ongoing counseling in about 3-4 months, correct?
Yes, he has done all his.
So you would agree with me, he hasn't just started his services, he's done a marathon and a pretty amazing job of getting it all done.
He has done a good job at getting it done.
And so only ongoing services he has left is counseling and then whatever random drug test you sent him to, correct?
Correct.
And he has complied with the requested drug test without any concerns, correct?
Correct.
Okay. Now, do you understand what Ms. Savage is requesting today?
I do.
What is she asking for?
For a monitor return for Serenity to return to Jessica's home.
Okay. And do you understand that if the court grants a monitor return, that means the case can get extended for 6 more months?
I do, yes.
And if the case gets extended for 6 more months, it'll give you plenty of time to keep drug testing these parents and monitoring their relationship and throwing whatever other services you want to throw at them.
That is true, yes.
And that will continue to assure Serenity's safety, correct?
Yes.
Okay. Do you believe that it would be in Serenity's best interest for the case to be continued and for you to monitor to make sure this transition goes smoothly?
I do believe it is in Serenity's best interest for this case to continue and be monitored.
Okay. No other questions?
Ms. Acosta.
Thank you, Judge. Ms. Lewis, as the custodian of records, did you review the outpatient notes for Ms. Shower?
I've been able to look through them, yes.
Were there any recommendations with regard to mental health to your knowledge?
I know there was a recommendation to continue to monitor her mental health as long.
And has that been done?
When I spoke to Jessica, she said that she hasn't really felt mental, like it was like depression, anxiety. She hadn't really felt that lately, and she would like to not be on medication if she could avoid that, just due to substance abuse concerns with that.
So that wasn't something that was recommended by a professional. It's just something she's decided she doesn't want to address.
I mean, she's addressing it in counseling, is the way she is addressing it.
Okay. How many visits has Ms. Shower had through the duration of this case?
I would say probably 30 plus.
Is that a guess?
Yes. I don't know the exact number. I apologize.
Okay. To your knowledge, has she made all of her visits?
To my knowledge, yes, she has. Since I've had the case, she has.
Okay. But prior to that, do you testified you don't know how many visits she's had, correct?
Yes.
Okay. Has Ms. Shower ever told you that she and Mr. Del Toro are not in a relationship?
She has not told me that since I've been the caseworker, no.
Okay. As the custodian of records in the file anywhere, was it notated that she had mentioned to anyone that they were not in a relationship?
I do believe that she did mention to Janelle at one point that she wasn't in a relationship with him and she was focusing on her sobriety.
Okay, so is it fair to say that their relationship status has changed during the course of this case?
Yes.
In these cases, is it important to see a long stretch of stability with the parents?
Yes.
And is it fair to say that that goes for relationships, housing, employment, pretty much across the board, correct?
Yes.
Okay. In this case, have you been able to observe stability in Ms. Shower and Mr. Del Toro's relationship?
Since I've been the caseworker, yes, they have been honest with me about their relationship. However, previous, I'm unsure.
Okay. And how long have you observed that?
Since November of 2022.
Okay. Do you think it's also important for them to show consistent employment stability?
Yes.
Okay. And how long has Ms. Shower demonstrated that currently?
Well, she did just get her new job beginning of January, but I do know that she was consistent with her employment back at Family Dollar in San Angelo.
Okay. And was that for how long was that for?
About 6 months from when she lived there to moving back.
Do you know what kind of employment she had prior to entering inpatient?
I do not.
Do you know, can you testify to what kind of stability she had with employment prior to that?
I don't believe so, no.
Okay, so to your knowledge, she's had stable employment for the number of months she was in inpatient or in sober living in San Angelo, and then
Yes.
for the few weeks that she's had here, correct?
Correct.
Okay. And for Mr. Del Toro, do you have any knowledge of stable employment for him over an extended time?
I do know that he's working Del Toro construction. He began that right after he got out of incarceration, and he's continued that. It's a family business.
Okay. To your knowledge, does Mr. Del Toro have any other children?
Not to my knowledge.
I'll pass the witness, Your Honor.
Any follow-up?
Yes, Judge, I have some. Ma'am, this case was set for trial on January 10th, 2023. Is that correct?
Yes.
And it got extended to today because there were some motions filed. Is that correct?
Correct.
Now, at trial, at the time of January 10th or today, can you say that the parents have completed their service plans?
They have not completed them.
That it's outside the scope.
Judge, I think it's relevant to this return and monitor motion.
Overruled.
But it's outside the scope. He had a chance to question, and he didn't cover that initially.
Judge, it's things were brought up. Judge, I'm asking. The service plan was talked out throughout every attorney's questioning. So I'm asking about the service plan.
Overruled.
So, Ms. Lewis, on January 10th, did the parents complete their service plans? Yes or no?
No.
Have the parents completed their service plans as of today, January 24th, 2023?
No.
have the parents had a year and a half to complete services and show that they can provide a safe and stable home to this child?
They have had a year and a half, yes.
Do you believe that the parents are trying to use this motion on a monitored return to complete their services?
Objection calls for speculation, and her belief is irrelevant.
Sustained. Let's rephrase that.
Do you believe the parents need more time to complete services?
Yes.
Do you believe that a motion for a monitored return should be used for parents to complete their services?
Objection again, Your Honor, her belief is irrelevant.
Judge, she can answer that. She's the custodian of record. She's the caseworker in this case. She has training regarding these CPS cases, Judge, and she knows the difference between what a monitored return is and a regular course of a CPS case.
He's not asking her to speculate. He's asking her what she feels is the custodian of records of this case, so I'll allow it overruled.
Will you ask me the question one more time? I apologize.
Okay, let's see if I can remember that question. So we did cover that the parents do need more time to complete services. Do you believe a motion for a monitored return should be used for parents to complete services?
I believe it depends on the case.
Well, depending on this case.
Depending on this case. Yeah. Yes, when it comes down to the services that they are needing to complete.
Okay, but this is a problem that was created at the parents because of the parents decided to engage in a relationship in November of 2022. Is that correct?
Yes.
What to your knowledge, what do you believe a motion to a return and monitor is?
That the child would be going back home to a parent or parents.
And do you believe the child should go home today to Jessica Showers?
I have not been able to fully staff that with my supervisor, so at this time, no.
Pass the witness, Judge. Thank you.
Ms. Lewis, what's the permanency goal as of today?
Verification.
The child up to date on her medical and dental?
Yes.
And are there any other concerns that need to be addressed, developmental concerns?
No, those are being addressed in ECI.
Would you classify Ms. Shower as being in compliance with her family plan of service?
Yes.
What about Mr. Del Toro?
Yes.
All right, Mr. Saldivar, next
I'd like
witness.
to call Ms. Wells.
She's been sworn. You may proceed.
Ms. Wells, can you state how you're related to this case?
Jessica Shower is my half sister.
Okay, and how long have you had Serenity in your home?
For almost a year and a half now.
Do you remember the date that they placed Serenity in your home?
Yes, September 13th.
Okay, and when she arrived in your home, was she suffering from any conditions?
Yeah, she was withdrawing.
Objection, hearsay.
So she has personal knowledge of the child's conditions.
She's not a doctor. It'd be information she learned from the child's doctor, which is hearsay.
Sustained.
Let's see here. When Serenity was dropped at your home, did you have to make any appointments?
Yes, we did.
And what appointments did you take Serenity to?
We started seeing a developmental specialist, and ECI also came out to work with us for getting her into physical therapy.
Okay. Were there any other specialists that you had to see when she arrived at your home?
Yes, we also see speech therapy as well.
Okay. And during this case, let me see here. Has she had any procedures or surgeries done?
Yes, we've had two.
And what surgeries did she have or procedures did she have?
She had to get tubes put in her ears, and she also had to get her tear ducts opened.
Okay. And to your knowledge, did Ms. Shower or Mr. Del Toro attend any of those surgeries?
No.
Now, how often do you have to take Serenity to the doctor?
For the developmental specialist, we were seeing her every couple of months. Now we're seeing her every 6 months. And then for speech therapy and SST, they come out for SST once a month and for speech twice a month.
Are you still, is she still engaged in physical therapy?
No, as of her first birthday, they stopped.
Oh, okay. Did Ms. Shower or Mr. Del Toro attend any of those doctor visits?
No.
And during the pendency of this case, have you received any support from Jessica Shower?
No.
Have you received any diapers, clothing?
She's given us diapers maybe once or twice, and then sometimes she'll give us toys, and then recently she just gave us a pack of socks.
Okay. Have you received any of that from Mr. Del Toro?
No.
And could you describe the bond that you have with Serenity at this time?
She calls us mom and dad. We're all she knows. We've taken care of her.
Did you say your and speculation?
Overruled.
Go ahead, Ms. Wells.
It's hard to explain. It's like taking care of someone you love so much. We sit with her while she's having an ear infection. When she cries at night, we hold her, we rock her to sleep every time. We just try to be there.
Narrative.
What was the objection?
Narrative.
All right, Mr. Saldivar, ask the next question.
You've heard a lot of testimony about the visits between Jessica Showers and the child. Did she, how many visits would you say that she had with the child during this case?
She's had a lot. How many? It's been over a year, so I have no idea how many.
Okay. Were there any issues or concerns that you had for the visitation that she had?
She was late to a lot of them by 45 minutes, an hour. There are some that she didn't show up to that we were dealing with.
Okay. And now she started unsupervised recently. Could you explain if there was any issues or concerns that you had?
We just had issues with getting last minute notice about when a visit needs to occur. We got a text on Friday while I was at work asking for a visit for the weekend, which we had plans for. So we weren't able to accommodate for that, but we did ask for a 48-hour notice just so that everyone is on the same page. And since that, it's worked out.
Okay. Have you ever alienated your sister from any of the visits?
No.
And how has Serenity reacted in any way to the unsupervised visits?
The last visit we did have, she did not sleep well at night. She was crying the whole night and we couldn't get her to sleep at all. She was just being very fussy and could not get her down.
Okay, is that typical behavior after the visits with mom, or was that something different?
That was something different.
Ms. Shower is asking for a return and monitor that the child be placed in her home here today. Do you have any concerns about that?
I do have concerns with that.
And what are your concerns that you have?
That there is history of domestic violence between her history and his history as well.
Okay, and is that the only concern that you have if the child's returned home?
And also just staying clean and sober.
Okay, and Ms. Shower testified that she's used methamphetamines for a while. Have you seen her throughout those years use methamphetamines?
Yes.
Okay, and to your knowledge, did she ever try to get help before this case for that methamphetamine use?
She has.
Okay, and to your knowledge, was that help successful?
No.
And can you please explain why you say no?
She did end up relapsing shortly after going into a sober living home.
Okay, and to your knowledge, how many times has she relapsed throughout the years?
I cannot count that many times.
Would you say it's more than 3 times that she's relapsed?
Yes.
Okay, so she's attempted to get help with this problem several times. Is that correct?
Yes.
Are you concerned about any potential relapse in the future?
Yes.
And why are you concerned for that?
She's shown it's a pattern. It's happened before. We've dealt with it before. I was also part of the process for the last time this did happen.
Okay. And when you say you were a part of the process, how are you a part of the process?
Me and my mom were the ones that did take the custody when we first got Aviana in Kingston.
Okay. So it was a similar kind of case with Kingston and Aviana, is that correct?
Yes.
And as far as Mr. Del Toro, to your knowledge, how many visits has he had?
I think 3.
Okay. And do you have concerns of Ms. Shower engaging in a relationship with Mr. Del Toro?
Yes.
And I know you testified earlier about the domestic violence, but other than that, do you have any concerns going forward about the relationship and Serenity being exposed to that?
Yes.
And could you please explain?
Just the fact that I personally don't know him, and just his history that we've brought up here, it's a concern for me.
Okay, pass the witness, Judge.
Yes, this last visit with the mom where Serenity was crying, when was that?
It was the most recent visit, the week of court on the Friday.
Okay. And there's been no other visits since then?
No.
Okay. Do you have any knowledge that Jessica is currently using any drugs?
No.
Do you have any knowledge that her home is currently poses any dangers to Serenity?
No.
Do you have any knowledge that she's currently engaged in any kind of a relationship where there's active domestic violence?
No.
Do you have any knowledge that Ms. Shower cannot meet the physical needs of Serenity at this time?
No.
I'll pass the witness, Your Honor.
Pearsall.
No questions.
Ms. Acosta.
Thank you, Judge. Ms. Wells, you mentioned that Serenity goes to a developmental specialist. Has Ms. Shower ever inquired about how those appointments are going?
No.
Has Ms. Shower ever inquired about what goes on with Serenity's speech therapy?
No.
Has she ever inquired about how either of her surgeries went?
No.
Has she ever asked about what's involved in her physical therapy?
No.
And Ms. Shower does have your phone number, correct?
Yes.
Okay. Ms. Wells, you also testified that you have concerns for drug use. To your knowledge, how many years has Ms. Shower had issues with meth?
Objection, Your Honor, it's been asked and answered.
Sustained.
To your knowledge, did Ms. Shower have a meth problem while she was with Mr. Del Toro previously?
Yes.
To your knowledge, do you know of any issues that arose from that?
Not any issues between the two.
Okay. How have you witnessed Jessica or Ms. Shower provide a stable home for any of her children for longer than a few months?
No.
And how many children does she have?
She has 4.
And all 4 of them are currently not in her custody, correct?
Yes.
Okay. And to your knowledge, is the reason drugs?
Drugs and alcohol, yes.
I'll pass the witness, Judge.
Any follow-up?
No, Your Honor.
Next witness, Mr. Saldivar.
No witnesses, Judge. Arrest.
Anybody else have a witness they intend to call?
No, Your Honor.
All right, let's start with arguments. Let's start with Ms. Savage.
Your Honor, in this case, the mother has completed all of her services. She's engaged in counseling, which is something that can continue for the remainder of her life. The department wants to take this scapegoat that, oh, now she needs couples counseling because she didn't tell us she was in a relationship at the beginning of the case, when there's proof that the department had information that she was in a relationship with Mr. Del Toro November of 21. So for them to say, oh, we had no knowledge, and now we're going to throw this in their bucket at the end of the case is not fair to Ms. Shower. In addition, a monitored return wouldn't make this case end. It would give the department to continue to monitor this mother and make sure that she's continued to comply with her services. She could continue going to counseling. She could continue going to couples counseling as well. She can continue drug testing. The evidence is that Ms. Shower is a fit parent at this time, and the law favors fit parents. She's clean. She's been sober for 8 months. She's had stable employment. Yes, she just got a new job, but she just moved across the state of Texas. She has housing that's been appropriate by CPS. The caseworker has said in her testimony that the mother is compliant right now, that the goal is reunification. So it would seem that the best course of action, if the goal is reunification, which is what the law favors and what is presumed to be in the best interest of the child, then that this monitored return should be granted. I understand that there's these concerns that in the future she might relapse, but the law isn't what's going to happen in the future. The law is if that parent is fit right now. In each permanency hearing, the court shall review if the placement for the child in the managing conservatorship of the department who has not returned it to the child's home. At the end of the hearing, the court shall order the department to order the department to return the child to the child's parent, unless the court finds that there is a continuing danger to the physical health or safety of the child. Ms. Shower isn't a danger to her child right now. Their concern is a relationship with Mr. Del Toro, and even Mr. Del Toro, he's engaged in services and he's clean. And they want to use a domestic violence incident that didn't happen with a paramour, that didn't happen with the child from 3 years ago. Right now, both parents are in compliance. Both parents are engaging and both want their child back in their home. I ask that this monitored return be granted, and if not a straight monitor return, that a transitional monitored return be granted, and that Serenity be able to go back home to her mother and her siblings, which would also be in Serenity's best interest.
Mr. Saldivar.
Yes, Judge. We were set for trial on June 10th in this case, Judge. You heard testimony that the parents are not completed with their services, and this is a last-ditch effort to try to get more time for these parents. You've already extended this case and given the parents an opportunity to finish services. They're trying to use a monitored return to complete what they have left. Mr. Del Toro, you heard testimony that Jessica Shower told the prior caseworker that she was going to work on herself and was not in a romantic relationship with Mr. Del Toro. Ms. Shower decided to complete services of domestic violence, drug classes, and everything, and decided to, the moment Mr. Del Toro got out of jail, jump back into a relationship. She put her needs over the needs of the child. She's engaged in a relationship with a convicted felon who had possession of methamphetamine and was convicted of domestic violence with his father, a family member, a close family member. He downplayed his drug use of 5 years of meth use, Judge. He said that wasn't a big deal. He chose to do it. He downplayed the domestic violence. He said it was a lie, but yet he took a conviction and went to jail for it. Jessica Shower decided that that was more important to engage in that relationship than provide a safe and stable home for Serenity. Now they need more time to complete their services, Judge. We don't have any therapy notes recommending reunification. We don't know how they're going to be as a couple. You heard testimony from Mr. Del Toro that he tried to change his address to Miss Shower's address after he got out, and that didn't work out. And the only reason why he's not living there today, Judge, is parole has put a stop to that. If it was up to them, they'd be living together and they'd be asking you to return the child to an individual who's only seen his child for a max of 5 hours. This child's a year and a half. She's lived the entire year and a half with Miss Haley Wells. She's bonded to Miss Wells. She calls her mom. She sees her as mom and her paramour as the father. Moving this child with Miss Showers, who's had a history of methamphetamine use through her own testimony for the last 4 to 5 years. She's relapsed. She's had to give her children to other family members to support them. She's gone to rehab, then she relapses again. It's a pattern, Judge. We're in this pattern. You do not have enough time to determine whether this is going to work for Miss Showers. She just moved down to Dilley. We don't even have 3 months of stability in her housing or work to show that she can support this child. The mechanism would be an extension for the parents to complete services, but they've already used that, Judge. Miss Wells is providing a safe and stable home. She's bonded to this placement, and I believe that it's in her best interest to stay there. I believe Miss Shower downplayed her relationship with Mr. Del Toro. There's concerns that we have that she will be around Mr. Del Toro during her visitation, and that's why we filed our motion to have her visits supervised. That information was not shared with you at the October hearing, Judge. And these 2 individuals have testified here today that they knew that they were in a relationship or they didn't know they were in a relationship, but that was never brought to your attention when you made the decision to allow her unsupervised visitation. You heard from my client that during her unsupervised visit, the child did have a reaction to that visit, Judge. And so we're asking that you grant, if you grant any more time in this case or move the trial back, that the visits be supervised for the best interest of the child, and that we either get sent to mediation or this case has been reset for trial. But we're asking you to deny the motion here today as it's not in the best interest of the child at this time. Thank you.
Thank you, Your Honor. The department, for the most part, aligns with the intervener in this case, as well as the ad litem. The concerns that we have are the same concerns that everyone else seems to acknowledge, including the parties themselves. Meth use, the jumping into a relationship so soon after sobriety has been reached, and the continuing of the cycle that Ms. Shower has engaged in through testimony for the last couple of years with each of her children, where she has not had ample time to sit in her sobriety before introducing an individual into that seems to impact her sobriety or at least doesn't help. Having an intervener and parents who are engaged in services fully is it's a good problem for the department to have, and it's encouraging that these parents are so fully engaged in their services. The concern that we have is that, as Mr. Saldivar stated, throughout the hearings in this case, there did not seem to be a full disclosure as to the nature of the relationship. It has been an issue in this case for the last year as to whether or not Mr. Del Toro is continuing to be a part of, or will continue to be a part of, Serenity's life. That's concerning because it shows a hesitation on Ms. Shower's part, at least, as to letting the department know fully about her life and the concerns that we'll inevitably have in regards to that. The department's goal in this case is not to move the finish line for parents and to encourage them to engage in services and then deny a return. But our hesitation is in jumping the gun. And as Mr. Del Toro admitted in his testimony, placing a child in the vicinity of parents who she just does not yet have a full relationship with and who are not ready to take her on full time. So the department at this time also requests that you deny the full monitored return.
What is the department's position on the supervised visitation request?
Until Ms. Lewis has had an opportunity and to review the therapy notes and the couples counseling, the department is also believes that there needs to be a little bit of reins put on back on visitation to allow for supervision of both parties together with the child.
Spearsall.
Your Honor, the goal of the department was very clearly told to you. It's family reunification. The court's legislative mandate is just as clear: reunify if at all possible. I'm not sure who came up with this theory that we didn't know these two parties were in a relationship, but I clearly recall a hearing where I bench warranted Mr. Del Toro to come into court. And at that time he was incarcerated, and the department testified that the permanency goal was family reunification back then too. And I asked which parent, and to my surprise, the worker said this both, which at the time made no sense to me until because Mr. Del Toro was incarcerated, until she explained that they're in a relationship. And that was testimony in open court from the department. This was never a secret. They've decided to pretend this was a secret at this late goal in the game. Mr. Saldivar argued to you, these parents have a history of drug use. They do. That's why this court exists. Quite frankly, none of us would be in business if it wasn't for people using drugs. And the whole point of the department is to rehabilitate families, to help them heal. And these two parents have done an absolutely amazing job. I don't think I've ever, in 23 years, have seen a parent do service plan in 3 months. I can count on one hand how many parents I've seen it do in 6. These parents are really committed and really on the ball. And Judge, honestly, to me, this case is just sad because Ms. Wells is family. And she could be this amazing support to her sister and be working with her and helping her and making sure she's always a safety net for this child. Instead, she's obviously sabotaging her sister, sabotaging this reunification, hiring an attorney, spending lots of money to downgrade her sister and fight against her. She is very much working against her. She didn't tell her sister, hey, your baby's having surgery. Hey, would you like to talk to your baby? We'll have a picture of her. She didn't even tell her about apparently 2 procedures that this child has had. I think it's very clear, even from department's own hesitant testimony, that the right thing to do is to order a monitored return with the mother of this child. And we don't disagree that Mr. Del Toro needs to continue to build his relationship. We're not asking to do absolutely anything to in any way, sabotage or interfere with that monitored return. We will comply with whatever visits that the court will continue to order for Mr. Del Toro. I am asking that you order makeup visits because the department has clearly violated that order. They've admitted to that. And so I think it's reasonable to at least increase his visits to 2 hours. And I would love for them to become weekly. I mean, he is way in compliance. But please, it's our request that you order monitored return and place the child immediately with the mother. And we will be happy to make sure we don't go anywhere near this child outside of supervised visitation on whatever terms the court orders.
Ms. Acosta.
Judge, I hear a lot of people talking about what the parents have done and what's fair to them, but in these cases, in every custody case, it comes down to the best interest of the child. And in this case in particular, the child's age and emotional and physical needs now and in the future are paramount. This child, Serenity's never known any other home than the one she's in now. She was born and went from the hospital to Ms. Wells' care, if I'm recalling correctly. She has been there for 1.5 years. And to say that she would be going home if she were to be returned to Ms. Shower today is false. I don't think that it's in her best interest to be returned at this time. I think that there's I think that mediation would be beneficial in this case. I do agree that we do have a lot of people here that love Serenity. I'm not trying to downplay what her parents want at all. But I do think that it's important to understand that Serenity's in the position she's in right now because of the actions of the parents. She didn't put herself in this position. They did. They didn't do their services within the first year. The case got extended and put Ms. Wells in a position where she was legally able to intervene into the case. And I think given Ms. Wells' testimony that she has observed repeated relapses by Ms. Shower, it's understandable as to why she's putting herself out there as, a permanent placement for Serenity. I think I don't disagree with Ms. Kyler Green when she speaks of, this is a difficult case, and it is a kind of good place to be in where everyone, the parents are doing what's on their service plan, and we have a placement who is, who loves this child, and who has provided a safe, stable environment for her for the past year and a half. But I think to just rip her out of that home and place her with Ms. Shower when she's never lived with her, she's never spent more than a few hours unsupervised by her. And I just don't think that would be fair. I think it's also important to note that Ms. Shower doesn't know what goes into, her therapies. And I don't think that it would be in Serenity's best interest to put her in a place where those things wouldn't be addressed, because per testimony in this case, mom hasn't reached out to figure out what those needs are. I heard a lot of testimony of, well, nobody told me. But if you find out, then you need to inquire what's going on as soon as you do find out. And I don't know that that's happening either. So I'm in line with Mr. Saldivar, and I'm in line with the department. I don't think that the monitored return would be in Serenity's best interest at this time, but I do think that this case is one that would benefit from mediation, because we do have 3 parties who obviously care about Serenity.
Thank you, Ms. Acosta. Ms. Savage, I'll give you a minute or 2 for rebuttal.
Your Honor, the reunification is the goal in these cases. These parents have done their services. Ms. Shower has done her services. She can provide a safe home for her child. The law favors returning a child to a fit parent. At this time, she's a fit parent. There's no immediate danger preventing returning this child home to her. I understand that there's concerns for the future, but that's not the law. And it's absolutely in a child's best interest to be able to have a relationship with their bio parents and her siblings. I fully feel that a monitored return at this time is in Serenity's best interest, and that's what the law requires. So I'd be requesting that be granted today. And again, in lieu, the transitional that has also been filed.
Mr. Saldivar, since you also filed a motion, I'll give you another minute or 2 for rebuttal.
Judge, I am in agreement with Ms. Acosta. You hear a lot about the parents saying, well, we've done this and this, but it's not really in the best interest of the child to move her from a home that she's lived in her entire life. The parents, you've given them enough time in a year and a half to form this bond, to finish these services. And in all reality, it's the parents' actions that's caused this delay, caused the fact that we're not completely done with services, or that there's a history of showing that they've learned from these and can provide a safe and stable home. Judge, and I didn't bring this up before, but and I believe everybody missed it, but we have the issue of a diluted sample so close to right before this hearing. You heard testimony from Ms. Shower that she drank water normally throughout her other tests. She's had multiple tests throughout this case. She was in the sober living home, never had this issue, and now we're here. I believe that does present a danger to this child, and engaging in a relationship with both individuals who have a very long history of meth use, and both who have a history of domestic violence, is a safety concern for this child to be returned home. And there was not enough time to assess whether that was overcome from these services, Judge. That's the truth, that's the facts, and that can't be changed here today. Thank you.
Well, we've had a 3-hour hearing, and I've heard quite a bit of evidence, and I've listened carefully to all of it. And I agree with a lot of what everyone is saying. I mean, there's a lot of very good points that have been made, but there's a few things that have stuck out to me throughout the course of the testimony. And I'm going to make a ruling on the motions, and then I'm going to make a ruling as to permanency. And Mom and Dad, I want you to listen closely and remember that we're in court. Court finds that there's a continuing danger to the physical health or safety of the child. Number one, Ms. Schauer has virtually no knowledge of the child's medical needs. She hasn't reached out to find out about it. She hasn't made an effort to find out about it. There was very little testimony as to what she knows about the child's medical needs. Court finds that returning the child to the mother or the father at this time would be contrary to the welfare of the child. I'm concerned about Mr. Del Toro's credibility. I'm concerned about Ms. Schauer's decision to willingly invite him back into her life so quickly while she's in the course of a CPS case. I agree with Mr. Saldivar. Mr. Del Toro, you completely downplayed your methamphetamine use for 5 years, and you completely downplayed the domestic violence charges against you. You took no responsibility for it. You said you didn't have a problem with it, that you chose to do it. Well, that concerns me even more than if you had a problem. I'm going to deny the monitored return. I'm going to grant the supervised visitation request. I'm going to order Ms. Schauer and Mr. Del Toro to engage in couples counseling, therapy, and address domestic violence concerns. For the purposes of the permanency hearing, court finds the permanency goal of family reunification. At this point in time, I'm concerned about that goal. I am. But Ms. Lewis testified to it and believes that Belong's goal should be family reunification. I've stated that I don't find that returning the child home right now is in the child's best interest. I think it's a concern. However, the goal can be family reunification without me returning the child home, because I made the finding that returning the child home today is contrary to the welfare of the child. I don't know that I necessarily agree with that permanency goal at this point in time, though. I want that on the record. Court finds that the placement is safe, appropriate, meeting the needs of the child, and in the best interest to continue. Court finds that Serenity's medical and dental are up to date, and the parents are in compliance with their family plan of service, but there's still concerns. I mean, you could be in compliance with your family plan, and I can still have concerns about the decisions that you're making. You can take every class that you're supposed to take. You can pass every drug test. But if you're engaging in behaviors or you're failing to do certain things that address the safety or the best interest of the child, it doesn't mean it's safe to send the child home. And that's where we are right now. I'm going to order the parties to mediation, and I'm setting the trial for February 28th, 2023 at 9:30. February 28th, 2023 at 9:30. We've reset it several times. The dismissal date on this case is March the 18th, 2023. I'm not inclined to extend this case at this point in time, and I don't want this to continue to get kicked down the road. The other thing I looked for, and I looked for in every pleading that was filed, is an objection to the associate judge, and there wasn't one. The only one that I found was untimely, and there's no jury demand. So we will go to trial on February the 28th, 2023 at 9:30, unless you all come up with something at mediation that I agreed to. That'll be the order of the court. Mr. Saldivar and Ms. Savage and Miss Kyler Green all have an order to prepare. I'll let the three of you discuss amongst yourselves how you want to do that. Obviously, you would each need to create your own order for your specific motion and the permanency hearing, but if you want to consolidate it into one, that's fine with me. Ms. Kyler Green, or excuse me, Ms. Savage or Mr. Saldivar, as far as your requested relief, not anything extra, is there anything I failed to address?
No, Your Honor.
Judge, I just need a clarification. So my motion's granted. What's going to be the visitation schedule for mom?
The visitation schedule is going to revert to what it was when it was supervised.
Okay. Just so that there's not a confusion between all the parties, could we just get the department to clarify that? Just because, Judge, I don't want to have to come back where everybody's fighting with each other.
It was once a month for 4 hours because she was in San Angelo. So
yeah, I was actually gonna say, yeah, it was that because she was in San Angelo. So I don't know what it will look like because now she's only 40 minutes from.
Well, it should be more often than that. I didn't realize it was only once a month for 4 hours. I would say every 2 weeks at a minimum.
Okay.
And I'm not saying that you're not authorized to have more visitation, but it's got to be supervised and it's got to be agreed or by court order. So let's say every 2 weeks for 2 hours. It's about the same amount of time. It's more in frequency than that. And with the authorization, if the parties agree to increase it. But I want to make it clear that one thing I think about in these types of cases is this case has been on the docket since September the 16th of 2021. I was looking at every hearing I've held in this case. And when we get to the end, and I feel like I still have some major concerns about choices that the parents are making and things that the parents are saying, I'm not inclined to open up the extension door. So keep that under your hats as you go to mediation. All right, that'll be the court's order. Thank you all for your time and your service. If nothing further, all parties are excused.
Are you setting it for like a contested lengthy trial on February 28th? So it's like a 30-minute setting.
Ms. Greenlee, what else do we have that day?
That is the only thing set.
So you'll have all day. We'll start at 8.
You want me to move it to 8?
Yes, ma'am.
Your Honor, I have a contested hearing that morning at 10 a.m.
You'll need to get coverage until you can be here.
Okay.
We have a looming dismissal date. It needs to move forward. Okay.